How to address a disclaimer in a trademark office action. Have you ever wondered how to handle a disclaimer when you receive a trademark office action? It can feel a bit overwhelming, but understanding the process can make it much easier. Let's break it down step by step. When you get an office action from the United States Patent and Trademark Office, it usually means that the trademark examining attorney has spotted something in your trademark that cannot be registered on its own. This is often because the term is descriptive, generic, or common. A disclaimer is a statement indicating that you do not claim exclusive rights to that specific part of your trademark. First, take a close look at the office action. Identify the exact wording or design element that the examiner wants you to disclaim. This is crucial because your disclaimer must match what the examiner has specified. The typical disclaimer statement reads, "No claim is made to the exclusive right to use disclaimed term apart from the mark as shown." Make sure to use this exact phrasing when you respond. Next, you will submit your response using the Trademark Electronic Application System, often referred to as TEAS. If you received a nonfinal office action, you will use the Response to Office Action form. For a final office action, you will need the Request for Reconsideration after Final Action form. When filling out the form, answer yes to the question about adding a disclaimer. Then, enter the exact wording or design description that needs to be disclaimed in the designated section. Do not include the standard disclaimer phrase itself, as the form automatically adds that for you. If the disclaimer is the only issue raised in the office action, submitting this response will usually allow your application to move forward toward registration. However, if there are other refusals or objections, you will need to address those as well. It is important to note that disclaiming a term does not stop others from using that term in their trademarks. It simply clarifies that you do not claim exclusive rights over that specific element. Responding to a disclaimer requirement can be straightforward, but it is essential to do it carefully. If you believe that the term should not be disclaimed because it is distinctive or part of a unitary mark, you can submit arguments or evidence to support your case. However, this can be complex and may require legal help. In summary, addressing a disclaimer in a trademark office action involves identifying the required disclaimer, preparing the precise statement, and submitting it through the correct TEAS form. This will help satisfy the examiner's requirements and keep your trademark application on track.